Famous Greek playwright Sophocles once said, "Men should pledge themselves to nothing, for reflection makes a liar of their resolution." Yet, in M&A deals, the human ability to stick to promises is critical. In a typical M&A agreement, it's the representations and warranties section that covers all the promises that the parties are making between each other. So let's talk about some of the most widely applicable reps and warranties that you'll find in an agreement. So number one, organization and authority of party. You're just saying, yes, I validly exist as an entity and I have the authority to enter into this agreement. Sometimes you also need to represent that you've paid all license and or franchise fees. Minutes book and corporate records. You need to represent that your minute book and your corporate records are all up to date, that they reflect all the actions, resolutions, and material changes that have happened in your entity. Particularly for a seller, you want to make sure that your minutes book is up to date. Financial statements. This is pretty simple. You're usually just saying, we're not lying on our financial statements. Every once in a while, you want to rephrase it if a boilerplate term says that you adhere to GAAP. And let's say, for example, that you don't actually strictly adhere. You just need to rephrase it so that it reflects the truth. Capitalization. Hopefully this would also be straightforward. It's just a description of the ownership of the company, whether that's common stock, preferred stock, if you reserve stock for incentive plans or have convertible debt. Title to property. This one's kind of interesting because it depends on your business and your industry, whether the buyer is going to want you to represent your good title to certain real property or certain other assets like equipment. Sometimes you might have to list those in an exhibit showing all of the property that you own. There's also other types of assets that might need to get listed depending on your industry, like accounts receivable, inventory. You might have to represent that it's actually in good condition or that you have a certain quantity, and sometimes material contracts, depending on how relevant that is to the purchase of the company. Also intellectual property, patents, copyrights, trademarks. For example, if you're a software company, you might have to make a representation about the log of your code base and any alterations that have happened. Finally, litigation. You will likely have to represent whether you have any lawsuits, whether there are any employee disputes, or if you're a manufacturer, if there have been any product recalls. Ultimately, the representations and warranties are promises made by each party. Generally, the seller has to make more extensive representations because they're the ones selling their company, and the buyer wants to make sure that they're telling the truth about various aspects of the sale. At the end of the day, for a buyer, having representations and warranties is not a replacement for doing quality due diligence. At Balaka Law, we help not only draft these terms and agreements as well as ancillary documents, but we can help manage your capitalization table as well as go through the due diligence process. Thank you very much.